Hey there. Welcome to our AP Legal Zone podcast brought to you by AP Lawyers. We are your top picks for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only, and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes.
Hello, I'm Angela Princewill, and joining me today is
Sherine Abdi, hello.
And Sherine Abdi. For those of you who don't know us, Sherine Abdi is an awesome family law lawyer at our firm. I'm also a family law lawyer. We are AP lawyers, and we are there fighting the good fight for our clients in all things family law. And it's April 1st, and it's been a month since there's been some changes to, the laws regarding family law. And we just wanted to talk to you about that. So some of you would have had, for those with active matters, you've probably noticed some of these changes. But for others, well, you heard it here first. And let's jump right into it. So for me, I think the main change that sort of resonated with me and I felt was long overdue had to do with the terminology. I've never really been a fan of the terms like custody and access because I just find that access just seems to minimize a parent's role in the upbringing of the child. And while custody there just seem to be a lot of fighting just to be that custodial parent. So we've always kind of talked in terms of parenting time and decision making responsibilities. It's even interesting. The other day I was looking at an order. Sharina, you and I actually worked on this trial together a couple of years ago, and it was refreshing to actually look at our order. And we were already using words like parenting time there, and we were saying things decision making responsibility and stuff like that. So, what are your thoughts?
Granted, it took a long time for these changes to come into place. Like they've been talked about for so many
Fair
years.
enough.
So I feel like we've kind of adopted them. I mean, I do find myself saying custody and access sometimes by accident. But yeah, like I think we were kind of, we kind of tried to adopt them before they actually came into effect. So I think that's kind of
so we were
why.
not were not the genius that came up with it.
Yeah.
Okay, so that's fair. We didn't come up with it, but we were early adopters. So the interesting thing is when you use the word custody, I find that people almost think about it in terms of a right. I like the idea of the decision-making responsibility. So if you have a family law matter, whether you're drafting an agreement now or you're bringing an application in court, you can't say custody anymore. It's decision-making responsibility. And I really like that because
it's not even confusing anymore because the distinction between what actually is custody and access was so different for what people interpreted it as. And I think it was like, okay, custody is the decision making, and I think a lot of people couldn't really, especially obviously if you're not in the field, you're like, these are terms you're not grappling with often, right? So they don't understand that that's the decision making, and then access is the actual time spent with the children or child.
The number of times that I've had to
explain it.
No, they're just the conversation and the clients are talking to you and they're so adamant about custody and they want shared custody, and it obviously with practice that's what they're saying is really not what they want, but having to explain to them like, I know you're saying custody, but this is really what you want. And it ties into something else as well. Like for a lot of people, custody, I'm a believer in that the day to day really matters a lot in the upbringing of a child. Yes, there's major milestones where you need to make, God forbid, those like health decisions. And again, even if you don't have custody, if it's an emergency decision, you can make it, right? But for most people, you have religion or you don't. Extracurriculars. So I find that those major decisions weren't really what people were more concerned about as they were the day to day. So I was kind of excited to also see that because now the changes in the law have also clearly specified that the parent that's with the child is the one that makes the day-to-day decision. So doesn't that just make it easier?
So much easier.
Yeah.
So much easier. Because I think a lot of the time they're like, well, I have decision making. Why are they making those decisions? And I'm like, well, actually, it's their time. So they're responsible for those day-to-day decisions. And like the majority is like the actual major decisions need to be made, obviously, pursuant to what your parenting decision making is outlined in your order or your agreement or whatever the terms that you guys came to.
Yes.
So that was really helpful.
Absolutely. Another thing that I noticed that's changed is rather than saying access or primary residence and all of the ways we try to explain it, it's now simplified to just parenting time.
Yeah, I can't get any more simpler than that. Like now I can actually say, yep, it's parenting time that you want. And they've actually, even like when I would be speaking to like clients in the past, like they would just say, I want parenting time. So it's nice that the language is now, it's easy to follow. It makes sense. People can understand it.
You know what's not so easy though is contact. Like, why did they introduce the word contact?
I agree. I think that may be a slippery slope because contact, honestly, for all intents and purposes, could really mean a lot of different things.
And it does.
Yeah.
It does. I mean, the nice thing is, at least contact only applies to people that are non-parents. So that's it's not a huge part of the parenting cases that we deal with. But I mean, for whatever that's worth, you know what, we did great.
Parent, you're asking for contact with the child, just for clarity. Or if you're a grandparent or particular, it's just contact if you're a non-parent.
Yeah.
So yeah, it is a little, you know what, but again, the majority of the cases are parents. So as long as the definitions and, you know, the terms are now more clarified in general, we can't ask for everything to be perfect. Right?
Exactly. So when you're in your process, so remember you're talking about decision-making responsibility, and that only applies to 4 major areas for the most part. So education, religion, extracurricular activities, and what's the other one?
Education.
No, education, religion, extracurriculars, and health. Yeah, and the health of the child. So that's the main 4 areas of decision-making responsibilities. Everything else is kind of day-to-day, and any parent that has the child in their time, and it doesn't matter if you're the parent with the majority of the parenting time and the other person has less, they still have sort of the right to make day-to-day decisions about the children while in their care, right? Because if you, and I can see a lot of parents being concerned about, you know, parenting ability and can he do it or can she do it and all of that. Well, it's not really, I think it's not perfect. I know you would rather maybe explain how things would be done and all of that, but inherent in creating these parenting schedules or creating a parenting plan is the best interest of the child. So they've kind of revamped the best interest of the child test as well. Since forever, we've always known that every decision that relates to a child has to be made in the best interest of the child, right? So that's a standard. Everyone's aware of that. People mouth off best interest of the child, even when doing things that are not in the child's best interest. So we all kind of got that settled. But so there's been some changes that have been made in the factors that are looked at. And I know what a lot of women are applauding, and I don't say this just because I'm a woman, but the statistics show that with domestic violence, now more referred to as family violence in the act, it's predominantly the female. It's usually mostly male to abusing the female. So it's not really me trying to perpetuate any gender roles here, but it's just the way it is. It's been something that's really been applauded in a way because it's been given more prominence, and there's a lot of criticisms, obviously, but it's also nice to know that at least front and center are factors that a court must consider if there's family violence involved, in your situation. So that's a great change. it's now mandatory when looking through those best interests of the child factors to really look at the family violence as well. And then in general, obviously now you're not asking for custody and access orders. It's just simple parenting orders. So whether you're asking for parenting time, decision-making responsibilities, whatever that is, you're just simply asking for a parenting order. So that's another like nice one. And
could we maybe define like the definition of like constitutes as family violence, maybe?
yeah, why don't you do that?
Okay, so it's like physical abuse, obviously, forced confinement, sexual abuse, threats of violence or bodily harm to any, so it doesn't have to necessarily be against the spouse or the partner, but even with regards to the children too. So threats of violence towards the children would be considered harassment, including stalking, failure to provide necessaries of life, psychological abuse, financial abuse is the common one, and threats to kill or harm property or obviously a person. So,
or even their pets. Yeah.
oh yeah, their pets. That was an interesting one. I mean, it's great because I mean, oftentimes pets are considered part of your family, and a threat to your pet obviously would leave you really concerned.
Yes. So, yeah, that was a good one. It's a very robust definition, and the act makes it clear that it includes, so it's a non-exhaustive list, so anything in any form that family violence manifests itself, it becomes a relevant factor in making parenting orders that are in a child's best interest.
Yes.
Yeah. So now another aspect. Actually, I want to jump to relocation because I'm so excited. There were other things I was going to talk about before that, but I want to jump to relocation because it's...
So what is relocation?
Yes. Since you asked, why don't I let you define it? So go ahead, Sherine.
So for those of you that may have already kind of had matters pending previously or, came across the terminology, it was previously referred to as mobility. And that's really the ability for, I guess, one party to move to a different, let's just call it a different province, different city, different, province. Didn't I say province?
Toronto
really
to Pickering,
just move
anywhere
with the child. And that is now been recalled as relocation. So now there's different requirements and a different, it's not really a requirement, but more
it's a framework.
It's a framework. Thank you.
I like that. I like that we have a framework for relocating because in the past when someone came to speak to us about mobility, there was the major decision that everyone knows, and it's still the leading decision on relocation now. But at least I like it didn't really set out the minimum requirements and just let you know exactly what you had to do. There was just sort of this game where you just wanted to move. The person said no, and then we just kept talking about it. Now it's clear that we have to. And it was nice that I had a recent consultation, and it was really nice to be able to say, okay,
these are the obligations that you have.
I said, do this. This is the act now tells you exactly what information needs to be included in there. And I'm like, that's all you have to do. And if he's really serious about objecting to it, then he has X number of days. And if in this case, it was the she that was trying to move. And I said, if he doesn't object, then you're free to move within 60 days. Don't you find that really refreshing?
Oh, it was very nice because Gordon and Gertz, which is the leading principal case in this matter, it's great. It's a great case, but now it's kind of clarified a procedure for you to kind of, if you aren't, if you want to implement a move, you have notice periods, and maybe you want to talk about kind of the different process since you actually just came about this issue recently, and maybe talk about the different notice requirements and the things that you have to do to be able to implement such a move.
Yeah, well, and when we used to decide, or when we used to try to advise clients about whether their move was a good idea or not, and trying to just kind of figure things out, even with the courts, we obviously always fell on the Gordon case, but I like that now the facts actually have best interests that are specific to relocation. what's the reason? I mean, some of them is what's the reason that the person's moving, the impact it would have on the person. Do you have decision making responsibility or parenting time, and how would it be impacted, right? Is there an existing order in place or is there none? So it makes it very clear, and it's not, the truth is there's never going to be any area of family law that's not subject to interpretation. So we're not naive and thinking that all of a sudden our problems are all solved, but at least it's nice to know that we kind of have this playbook and this guide. And for a lot of people, if someone's reason for relocating wasn't so clear in the past, or wasn't so strong, I should say, then we can make it clear to them using these factors. It's a lot easier, I guess, to ask the person to go read these few enumerated factors in the act than asking them to go read a case law, don't you think?
No, 100%. One actually interesting thing is a lot of people, I'll find that like in agreements or in court orders, will implement, the ability to not actually relocate. But that's actually not enforceable. So in dealing with relocation, unfortunately, if you don't have an agreement, then this like framework, obviously without going to litigation, is very useful.
Yes, it is. So yeah, so that's so hopefully that would, we're yet to see. So with relocation, it's one of those that we might want to have this conversation a few years from now to see
how it's worked out.
Yeah, to see how it's worked out. But it's one of those things that the family law bar we're really excited about, to just at least just have a framework, have something that we can. I just like the notice requirements because a lot of back and forth. Let's just put in the notice. If it's an actual no, then you enumerate, you have to articulate the reasons why you're refusing, and then we can match it against what's in the best interest of the child. Maybe it would give us more clarity. In the couple of consultations that I've had on this matter, I can't really say that the act made the biggest difference in terms of thinking of what's in the best interest of the child because we already had Gordon, but it helped a lot in making the client know if you're planning to move for a lot of them it was in the fall. I'm like, you know what, you might as well just give notice now so that he has his 60 days and then we can see how things go from there. And also for someone else as well receiving that notice that someone wants to move, you don't have to panic. You understand that they can't just tell you today and move next weekend. They have to they have to wait the 30 days and all of that for you to file your response and things.
And sometimes you might not even dispute it, right? Like sometimes you'll have your time to grapple with, if you have the proper notice, you'll actually have the time to grapple with, okay, is this something I can work with? Is this something I'm opposing? And then you can go from there. But it kind of helps with the timelines.
Yes.
And then it helps people get more, I guess, conceptually okay or not okay with the decision that's about to be made.
Exactly. So, yeah. So let's talk about, another section that I like, which is, it's just the heading itself just says it all for me, where it says decision-making responsibility, parenting time and contact - duties. Like, I just like that there's just something about reflecting parenting in the terms of duties that I just kind of like. Maybe it's just me. I know it's just words, but I think it's a responsibility that needs to be taken seriously. It's a duty, it's a labor of love, but underlining the word there, labor. So I like that this is kind of highlighting that. So the act talks about now that every decision, I mean, we all knew this sort of, but it's nice that they decided to spell it out, that every decision has to be made in accordance with the best interest of the child. Parents are now have a duty to protect their children from the conflict that are part of their proceedings, and then alternate dispute resolution processes. So now we have the obligation to try. Well, I mean, obviously it's qualified where it's appropriate to try alternative dispute resolution processes. So Sherine, what's kind of been your experience? I know you do a lot of like mediation and things like that. I'm a trained collaborative lawyer. I'm also a mediator. So obviously we're champions of the alternate dispute resolution processes. But for parenting, don't you find that it's even, I don't want to use the word more effective and minimize what happens in the courts, but I think I would have to say it's more effective.
I have to agree. It's like more effective at this point because of COVID, because of the backlog and the time constraints that the court has to really deal with all of the nitty, the gritty, all of the little details that particularly I find that my clients really want addressed, and it's unfortunate, but like there are page limits to briefs before a court, and to be honest, the courts tell you like we don't need to be dealing with such small minuscule issues. Like that is something that parents are going to have to deal with when the lawyers are gone, when the judges are gone.
But for the parents, it looks like a big thing. Like it's when you say for the courts, it's almost like it's minimized. But the difference for a parent, the difference between a 2 o'clock pickup time and
no, I'm not diminishing the importance of it.
No,
I'm
I
saying,
agree.
but I'm saying like if you have someone who's willing to work with you on the time, which is a mediator or a parenting coordinator, sitting down, being able to work with your schedules, figuring out what the conflicts are.
No, I agree with you. A court is too overwhelmed to do any of that.
And
For them, it's trivial. For them, it really is. That's how it's seen.
So I highly recommend mediation. Obviously, now it's actually our duty to recommend, if you haven't known, what some of the Divorce Act changes require that a legal obligation on lawyers to actually let their clients know that mediation, if it's appropriate, obviously, is an option. And there are ADR processes, so mediation, arbitration.
There's collaborative law made it in there, negotiations. And that's the thing with our family as well. It's always surprising to me, and we really try to avoid this, but it's always surprising to me when I get a new file and the first hello we get is just a court application.
100%.
And it's like, could we just say hi here? Like, you know?
I mean, sometimes it doesn't need, like, granted, there are cases where, of course, like, we do need that neutral third party, and sometimes, unfortunately, it does need to go to litigation.
Immediately,
but, at this day and age, like, there's nothing that negotiations we couldn't start with.
Exactly.
Least, or explore the option of mediation. And if you want that binding decision, if you really are, let's say mediation is obviously appropriate for you, but you know it's that you're never going to agree, then that's what arbitration is for. And you could do the practice of med-arb, which is mediation arbitration. And then if you're unable to agree on the day of mediation, then you move for a motion for arbitration to arbitrate the issue on a final basis. So it's helpful in getting a final order, just as you would if you were in litigation. And obviously it could be more time effective and cost effective.
But people get concerned with the cost of mediation, and I guess the hard part with mediation is because things can move very quickly, there's a lot of upfront costs, but people, and it looks like it's expensive. I mean, you have to pay your mediator, but I mean...
I've never found that to be the case, but yes, like, I mean, from the client's perspective, it's like, oh, that's a huge retainer, or it's gone after my first or second day of mediation, and I'm like... But look at the progress you've made. And reality is you would have spent that at one conference, or you never really know. But it's because if you're in litigation, you're not paying a lump sum to just,
except you're at the trial stage.
Right. But also like there's so much time in between your conferences. And so maybe you're not seeing the money like flow that like, it's not coming out of your pocket like such a large amount at a time, so that you're not really seeing how much you're actually spending. But I've never found that mediation was more expensive than litigation.
It's always cheaper. Always cheaper. And I know the fear of mediation. People just don't want to go there and sit and talk and talk and talk. And that's why, Sherine said, let's do the mediation arbitration process. And with mediation as well, sometimes we go to court, and it takes, if you have two skilled lawyers, clearly there's many times where we look at, paperwork that's been filed by both sides, and we can say, well, let's enter into an order on some things because I can see that we don't disagree. But with a little less skilled lawyers, you could find yourself things dragging on for so long, and maybe the deal breaker is just one thing, right? And with mediation, you have the benefit of at least settling a lot of things, and then if there's just that one or two things, then your court cost is reduced when it's focused on just a few things.
100%. You can narrow the issues. Let's say like you already know like parenting, you're a little closer, but like you need some help. You need a neutral third party to get in there and work with you and your lawyers. And that sometimes can just settle the parenting issue. But the financial piece, maybe you want a judge's input, or a seasoned, mediator that's, experienced in family law, because there are complex issues that you need to deal with. So that would be something that obviously mediation is still great for it, narrows the issues, or any ADR process.
Exactly. So yeah, so at least it's nice that it's now an obligation, and yeah, we have to recommend it to our clients in appropriate circumstances. So those are some of the exciting that's really the bulk of it. Obviously there's a few minor things here and there, but we've given it all to you. This is the bulk of the changes that are in effect. They've been in effect since March 1st, and we wish you all the best in your family law matters going forward. And yeah, and join us next time on our next podcast.
Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Please be sure to subscribe to our podcast today so you can stay connected with any episodes and updates. And if you need a lawyer or would like more information regarding your legal matter, please check out our firm website that can be found in the bio.